Well, hello. It looks like our participants are coming into the session now. Welcome to our session, Meeting Client Deadlines and Managing Continuous FinCEN Filings. This is a very timely topic. So excited to be here today. My name is Michelle Brown, and I'm the Chief Growth and Innovation Officer here at MACPA. It's my pleasure to introduce our speaker, Charles Wismer. Charles is a thought leader in the FinCEN compliance space. He is one of the creators and the CEO of FinCEN Fetch, a leading BOI filing solution used by hundreds of firms across the United States. Charles is here with us today, and he's going to share some very timely insights and more during this session. Thank you for being here, Charles, and over to you.
Thank you, Michelle, and I appreciate everyone for joining me today for this CPE. So as mentioned, I'm Charles Wismer, and this is Meeting Client BOI Deadlines and Managing Continuous FinCEN Filings. And we are going to touch upon the injunction. Don't worry, that's definitely a core piece of the updated content here today. A little bit of background on myself. So I'm the CEO of a company called FinCEN Fetch. We've been spending 24/7 in the BOI world here for the better part of the last 2 years. We have a solution for law and accounting firms to help file these reports. So it puts us in this very unique position where we speak to lots of firms across the country. We serve about 1,000. I've had conversations with probably north of 10,000 now. And what we do is we bring that content, that data, that insight here, and condense it into CPE courses for you to keep you aware of all of the updates to BOI and kind of what the market is doing around, pricing, continuous compliance, what it looks like to manage this in an ongoing basis. So some things that we'll touch upon today, some of the common questions that we're seeing from firms and clients around this, a quick update on penalties and this new willful criteria. Not a lot of firms are aware that the penalties around BOI reports are around the basis of willful violations. Different pathways available for BOI reporting, some hands-on, some hands-off pathways, really kind of a firm preference point there. Market analysis, some updated data on what market pricing looks like, what ongoing compliance looks like, what it looks like to support ongoing CTA compliance, general errors that you're going to come across when fixing client reports. So we're going to dive into that as well. And then some helpful links at the end. For the questions, one thing that would help is if you put those in the chat. I also have Monica with our team here as well in the room, so she'd be happy to answer those for you. We also have some resources we'll probably put in the chat here. We have a new, we'll touch upon this too. We have a new Corporate Transparency Act appeal tracker because we're in this interesting situation now around the BOI reports and the relevant appeal as well that just populated from the government side. So to give you a little bit of background, of course, the BOI reports, they did require mandatory filings from companies. Let me just kind of move to, some pertinent information there in the background while we talk about this. So if you were a reporting company in the US, you had to file a BOI report. This is a report that includes company information, ownership information, company applicant information, and the deadline to do that for all of the existing companies, which is defined as a company that existed in 2023 or before, was the 1st of January 2025. So, roughly in 14 days from now. Now, an interesting development happened that actually shifted these filings to voluntary as of right now. And the important thing I'm going to say here is as of right now. It's a very fluid situation. In fact, this is one of those kind of uniquely historical moments when you see, a federal district court filing an injunction that prohibits a federal regulator from doing their job. So we have, right now, district court against federal regulator represented by Department of Justice. Really unique environment, really unique case going on. It's definitely something that's getting rapidly expedited in a pace that we've never really seen, for most cases as they travel through the court. But to give you a little bit of background, there was a federal judge in Texas. This federal judge was, hearing a case related to the BOI reporting. And the federal judges, they have a lot of power. So they can say that, okay, I don't see the BOI reporting process as something that's constitutional. So, for example, you don't have to do this. And, they can put out an order for this. Now, most of the time when a federal judge puts out an order, it affects just the plaintiff, the person who brought the action to say, I don't want to do this specific filing. Now, in this unique case, the federal judge decided to apply the order nationwide. So it's an injunction against the enforcement of the BOI report nationwide, rolling out to all 50 states, all jurisdictions. Interesting thing is there's about 5 of these cases going on right now. There was an early one that was very popular in the media in Alabama. It's currently in appeal. It led to the judge essentially creating an injunction against roughly the 60,000 plaintiffs in the group, in the plaintiffs group, but not the, nearly 40 million US companies. Now, the one in Texas, the judge, decided to apply that injunction ruling nationwide. So that's a different dynamic here. There have been another couple of cases in the last couple of months where the federal judges declined to issue an injunction whatsoever. So there's definitely some precedent where, some courts are saying the BOI is something that's proceeding as well. But the interesting one about the Texas one, it is currently made BOI reporting voluntary, meaning that the law isn't gone, the regulation isn't gone, but FinCEN's ability to enforce it is currently suspended. So FinCEN has responded by saying that, okay, the BOI reporting is currently voluntary while we go through the appeal process. However, there's an extra dynamic here in play. Through the Department of Justice, they filed an appeal very, very fast. So that appeal was just filed very recently in the Fifth Circuit in Louisiana. So the Fifth Circuit in Louisiana has actually requested, and this is information as of just yesterday, has requested all parties get their final documents in on Thursday. So there's some high likelihood that an actual ruling could be made to either, I guess, what would you call this, to stay the injunction, meaning BOI could be back in effect on Friday if the judge sides with, the government and FinCEN. Likewise, it could go the other way where the judge could say, you know what, we're going to keep the injunction in place until this appeal plays out. Appeals can be long processes, but due to the parties involved here, it's going to be much faster than your average appeal. But anyways, the reason I say it's a very fluid situation is the thing to know right now, you do not have to do a BOI report by the deadline in 14 days. As of Friday, that could change. So definitely something to be highly aware of. In fact, one thing I think that would be very helpful, Monica, if you want to put our appeal tracker page in the chat, all of our firms are bookmarking this. As the case develops, we publish documents in there and let you know what's advancing. So if your clients may or may not have to do BOI reporting and you need to know that information, that page is an excellent place to get up-to-date resources. We actually pull the documents down from Pacer every day and put them in there if they're relevant and things you need to know about. So anyways, definitely CTA appeal tracker, that's in the chat. So I want to move into the rest of this now, but I do want to give you all of the latest information. Cliff notes there. The injunction stopped the enforcement of it. Federal government very quickly filed the appeal. They're asking for a stay of that injunction, which would reactivate the BOI deadline. Likely by Friday, some more information will be known around this. But one thing that we have also heard from a lot of our firms is that we work with about 1,000 of them, so we do have a lot of data. About 50% of our firms are continuing to collect information because they don't want to get caught off guard if, this thing gets stayed and then they have basically, 10 days crossing Christmas to get this in for their clients. That's super inconvenient. So a lot of firms are taking that direction. About 20% of the firms are saying, we're just going to wait. We're not going to do this at all. And about 30% of our firms are continuing to file and advise the clients to file just in case. So, your strategy is yours to determine. But anyways, just to give you some breakdown on the different options at play there. Anyways, but the rest of this CPE, is based on, of course, not this very fluid situation. Ending up in a repeal of the Corporate Transparency Act is the information that you need to know if the Corporate Transparency Act, continues to move forward, which is probably a likely situation at this point. But anyway, so we're going to go into that part of the content now. If you have any questions, happy to address those. The letter is BOI. It means beneficial ownership information, and then it's a report. So you often see a BOIR, beneficial ownership information report. All right. So some common questions that we see around the BOI report. When you're explaining this to clients, they're going to have a lot of questions around, what's going on? Why do I have to do this? What's the purpose of this? So to give you a little bit of background, the easiest way to explain this to clients is to explain that the Corporate Transparency Act, it was part of the National Defense Authorization Act in 2021. Clients might not necessarily want to hear that part, but the next part is important to be able to express to them. It's designed to give the government a database where they're able to type in a name or type in a company and see all of the people attached and making decisions for those entities across the US. It's a law enforcement tool. It's only able to be used in active investigations by the government or law enforcement. It is not a public database. So if they have a private, Wyoming LLC, Delaware LLC, Nevada, those states that protect corporate privacy, that remains intact. But of course, if they're under investigation by the government itself, the government would have a tool to be able to see who owns and controls it after this report is filed. But anyways, that's definitely an important thing to point out for them, is that it is not, it is not a public database that immediately breaches all of their confidentiality, based on those very popular jurisdictions that, people often incorporate through for that very specific reason. So anyways, next, details on, what it looks like to do one of these reports as well. So the initial reports are due within 90 days of creating a new company in 2024. That is shortening to 30 days in 2025. So something to remember is, if one of your clients creates an entity, a new formation, it is important that they file a BOI report basically right away. It's going to become essentially part of the incorporation process. So it's going to be, incorporate the company, get the EIN, do the BOI report. It will be, part of that flow to avoid any penalties going their way. So that's something really important to know about the process. For the existing companies, now as of right now, this is suspended. As I explained, it's a very fluid situation, but as of right now, this is suspended. For the existing companies, 2023 formed and before, they have until essentially 14 days was the initial deadline that they had to get these reports in. So over the course of the year, FinCEN received roughly, and this is updated since, about 10 million reports. They need about 30 million reports. So there are a lot of companies that haven't done this yet, just to be very clear on that. They need about 30 million reports. There are about 10 million so far in the database. This injunction has, of course, slowed things down. So there's a high potential that a lot of companies are going to be out of compliance. How does FinCEN react to that? That's to be determined. Do they extend the deadline? Do they start penalizing? It's not really known, but a lot of this is, of course, up in the air, while this injunction is in place. Now, the other important thing to know, we hear a lot about one and done, and it's a quick report. You just have to do the report, and then you don't have to worry about this anymore. The important thing to tell clients is, if any data point on a BOI report changes, it requires an updated report within 30 days. I'm going to explain the reason why that's in place. So the goal of this database is to create an active directory where FinCEN is able to essentially type in a name or a company name and find all the people attached to it. Now, if that database was to get out of date, 18 months later, all of those owners have changed, people have moved around, the company addresses have changed, it's no longer a useful tool for the government. So the government has required updated reports be filed within 30 days anytime a change happens. I can describe some of those changes, the most common ones, because fortunately we see a lot of that data flow through our system. And for updated reports, the most common updates are going to be a change to a beneficial owner's address or their ID number. So these are two very common ones we see. These are followed by adding, removing, or changing an owner on a company. So, for example, they add another decision maker or a person with substantial control. Another one is going to be office address changes, and then things like adding DBAs. These other ones we're going to see as well, kind of following after that. If you want to kind of get a picture on how often an updated report is going to be filed, say you have a company that has 3 owners on them, and those 3 owners have unique addresses. 11% of households change residence in any given year. So that's a 33% chance of changing just due to an owner's address changing. When you also look at, states, for example, that, might have new ID numbers on reissuance, this is a growing trend now amongst the DMVs, a very inconvenient growing trend. That can trigger an updated report. Office address is changing, updated report. So, collectively, probably a 1 in 3 chance from address changes, and you add in adding owners, removing owners, changing owners, office addresses, DBAs. It's probably about 1 in 2 companies. Be extra aware of this if you work with early stage companies, because they are often adding decision makers on rapidly. or homeowners associations. They're not exempt from filing. They do have to file. They have a huge amount of turnover of their board officers because they're volunteer positions. They get yelled at by their neighbors. They quit a lot. New people have to come in because they need to keep a minimum amount. We see an enormous amount of updated reports come from HOA. So if you're dealing with these specific verticals, and just think through your client base, if you have a lot more owners shifting just due to maybe the niche clients you work with, definitely consider that, in your strategy around making people aware of updated reports. So essentially, which companies need to file? We get this question a lot. This one's pretty straightforward. If you create an entity by filing a document with a Secretary of State or similar, you must file a BOI report unless that company has an exemption. The most common exemption is pretty straightforward. It's the large operating company exemption. That means you have 5 million or more in annual revenue, you have 21 or more full-time employees, and a U.S. office presence. All three prongs are met. You don't have to file a BOI report. The other ones we'll see are going to be nonprofits, but they are specific types of nonprofits, things like churches and whatnot. I forget the exact classification, but the nonprofits for public good or those kinds of ones do have an exemption from filing. So it's not every nonprofit. Be aware of that. Also, state licensed insurance producers, they have an exemption. To be honest with you, there are not a lot of common other exemptions, and I will show you that exemptions list later on in this session. But you'll see if you can remember those ones, that's going to cover most of them that you'll actually see in the field. The rest are for securities issuers, banks. You get the idea there. Very, very rare ones. So if a company files a document with the Secretary of State creating an entity and it doesn't have an exemption, it needs to do this report. The report itself, it's 3 sections of information. Company information, we'll dive into what that looks like here as well. Information about every beneficial owner, and a note on the beneficial owners. The beneficial owners include multiple criteria here. So it includes anyone with 25% or more ownership in the entity, and it also includes substantial control. This is a new definition. To put it very easy in a sentence for you so you can remember this, substantial control basically means you can make important decisions for the entity autonomously. So if you're a CEO, CFO, COO, general counsel, board director, president, these kind of roles in the entity are roles similar to them, then you have substantial control. You need to be on the report, even if you don't have, any equity whatsoever. So it's 25% or more equity or substantial control. Either of those qualifications make you a beneficial owner under this regulation. You get a lot of questions why. Easy way to think about this is, even if somebody, concealed themselves from the cap table, but they pull all the strings and they're puppet mastering this, malicious organization or something like that, FinCEN would want to know who that person is, right? So that's why they want the substantial control, people in the database for the purpose of making sure that they're in there. That's a really important detail. And then we do hear a lot about, the penalties. So we're going to talk a little bit to those penalties. The penalties are $591 per day, or $10,000, or up to 2 years in jail. So you hear a lot of those numbers thrown around. Most common one you'll hear is the $591 per day. I want to highlight something though. Piece of information that is not well, shared around this. These are for willful violations. If you look at FinCEN's videos or any of their documentation or things they share, they clearly indicate and state on every possible occasion they can, it is not their intention to go after, good-natured businesses that are doing their best to comply with this, right? They are looking for those businesses that don't, do the filings or willfully filing, wrong information. So you notice for all the penalties, they're for willful violations. They don't want to go after everyone for, having a small typo in their suite number or something like that on the report. That's not the goal of FinCEN. They made it very, very clear for that. They're just trying to get a database. They're trying to enact the CTA, get this database live, not penalize businesses for small amounts of typos. And to kind of put this practically as well, there's going to be a lot of businesses so far that haven't filed yet that won't meet the deadline. There's going to be a large bucket of businesses that are having just a hard time, getting this in there. So if your clients are at least trying to do this filing by the deadlines, assuming that they're, reinstated and whatnot, very unlikely that they're going to fall into that willful violation bucket or be, high on the list of enforcement here as compared to the likely millions of companies who won't be in this database in time. So I just want to touch upon a little bit about, what puts you all on the front lines here as CPAs for the BOI regulation. And in fact, I think it might actually be helpful to show you this in real time as well. Oh, let me just pause for some questions. Accounting firms are exempt from filing BOI. Did AICPA request for extension? AICPA has been pushing for extensions for this. Yes, they absolutely have. They're a great advocate, trying to move that forward for you all. Now, accounting firms registered in accordance with Section 102 of Sarbanes-Oxley are exempt. So definitely know that criteria around it. Question from Kathy. The initial filing requires a driver's license or identification. If BOI addresses change and they have to provide a new driver's license, it's possible they might not have the new license within 30 days. That's absolutely correct. Yes. So if the address changes on the driver's license, technically the BOI report doesn't need to be updated from the new address on the driver's license, but rather just having the new address. So if a beneficial owner's primary residential address changes, they actually should file it based on that, because the recorded data point for the actual ID is the ID number. So if the ID number is staying the same, then technically that one isn't necessarily a trigger for the update, but they should have already filed with the new address itself, which would cover that anyways. Now, as I said, one thing to be aware, some DMVs and equivalent organizations are starting to change the driver's license numbers for security because, obviously they get leaked and whatnot. And then, if they never change, they could never remedy that situation. So a lot of the DMVs are starting to incorporate processes where when they reissue a driver's license, the number will change. So watch out for that, because that is an upcoming trigger of updated reports. We're already seeing that, coming in Florida, for example. So just be aware of that possibility through your state. Is a BOI needed if the registration with the state is only for a trade name? This would be a Schedule C with no federal ID number. We've seen things go back and forth on that because it's registering by filing a document with the Secretary of State or similar. So they haven't provided direct clarity on this situation exactly, but I do know a lot of firms that are filing those to be on the safe side, and they're recording the Social Security number as the federal or the federal taxpayer identification number field, which is an optional drop down. Joe saw that only 6.5 million have filed. If correct, it seems like low compliance. It is low compliance. It's currently about 10 million. But yeah, no, it is low compliance. If a company is exempt from filing but changes ownership and is still a large company, do they need to file? No, if they have the exemption in the first place, they don't need to file at all, even if that ownership changes. Okay, let me see what else we have here. I'm just going to scroll up just a little bit. Are DoD and other federal government agencies required to file these reports? They're conveniently exempt. They are. What about a homeowners association? Are they required to file info for every owner? For the HOAs, it's the board members, typically the officers that are on the reports, because they have substantial control. Nobody in an HOA will meet the 25% threshold. But because we see, those people make important decisions, FinCEN's outlook on this is there's always one beneficial ownership or beneficial owner on a report, because even if 100 people have 1% ownership, somebody makes the decisions, so that somebody has substantial control, and that person must be on the report. And the voluntary report started yesterday. You can fill out the paperwork you mentioned, but can we submit the report during the stop period? I tried yesterday, but it did not go through. Sometimes FinCEN system can be a little clunky. I'd recommend maybe submitting it again. You can technically file a voluntary report right now. We have a lot of that volume going through. You are able to file these, assuming that this portal didn't have an error at that specific time. All right, so shifting back to some of this content, and I just want to pull up one thing for you as well to show you kind of where this is. We get a lot of questions around, are we able to help clients with these reports and whatnot? So I'm just going to show you a couple of things on the FAQ here. Okay, so this is FinCEN's site for BOI, and we're going to go down to section B7. Is a reporting company required to use an attorney, CPA, enrolled agent, or their service provider? No, you're not required to, but if you need help meeting your obligations, you can consult with professional services such as lawyers, accountants, there you are, or enrolled agents. They actually recently added enrolled agents as well. They also recently added this one here. Okay, B9, because they had a whole lot of questions from people. Is this practice of law? Can I do this? So the way that the practice of law works, it's determined at the state level, typically with input from the bar associations at the state. We work with a lot of the bar associations too. We have a lot of these conversations as well with them. What they generally do to figure out UPL is they rely on guidance from federal regulators or whoever the relevant jurisdiction and organization that can actually establish those rules. So in the case of this, they rely on guidance from folks like FinCEN to be able to do that. That is not to say that a state can't deviate from that script and say BOI reports are a practice of law. We've decided it so. That can absolutely happen. Practically, is that likely to happen? It's unlikely. Anyways, but they did want to clarify this as well for everyone, that FinCEN considers nothing in the Corporate Transparency Act or FinCEN regulations prevents a third-party provider who is not an attorney from submitting a reporting company's report. Whether an action qualifies as unauthorized practice of law, however, is generally determined by state law and thus may vary. So anyways, they wanted to be very clear on that they don't consider it to be UPL, but do watch out for, local state laws if they were to emerge, stating that no, accountants couldn't touch these. I also think that's going to be extra unlikely because it seems like the legal field has actually been pushing more of this filing process and volume over to the accounting side. We've seen an increasing trend of that. Some anecdotal evidence around that, early in the year, we would, see for every 5 demos that we would do for law firms for our software, we'd have 1 for accounting firms. That has definitely flip-flopped. We now have 5 for accounting versus every 1 for law. The reason is that when clients are thinking about this and they're hearing about the BOI report, they're hearing a couple of things. They're hearing FinCEN, but they're also hearing Department of Treasury. And when they hear Department of Treasury, they're of course thinking of you all because they know Department of Treasury and they know IRS. So anyways, you all end up being more on the front lines about with dealing with these reports. One other thing to be aware of too is that the Internal Revenue Services database is parallel to FinCEN's because they're both under Department of Treasury. So another note is it's important to make sure that those 2 things match. So if you're filing say a corporate tax return that has 3 owners with 30% on it, or same for a partnership or something like that, you would want to make sure that the FinCEN BOI report matches that information as well. And then, generally you end up having more frequent touch bases with your clients as well. So you're going to be more aware of, if something changed about the company, owners are changed, addresses are updated, things like that. And definitely around tax time, attorneys might go years without working with a client if there's no new paperwork or something like that needed. Whereas you all might touch base with them monthly or quarterly, and definitely typically annually. So anyway, something to be aware of. It's definitely seeming like the volume of these reports when professional services is getting involved to help is falling to the accounting side. We covered how many reports have been filed to date already. And then something else to note as well, there are some options to make this easier. So we've seen a lot of firms start to plan a strategy around tax season of taking a look at the BOI transcripts for their clients and just making sure that matches what you're about to file for the tax return. For the same reason I mentioned, they're going into databases that are under, technically the same top level organization there as well. So you'd want to make sure that everything is going to match between those 2. So we are seeing, different approaches to that. We're seeing, where you're going to check the return when it comes time for tax season against the BOI report, from the transcript they provide. We see some firms are deploying, regular broadcast emails to their client bases, letting them know, hey, if anything has changed about your company, please, request an updated BOI report for me within 30 days of the change. Here are 7 common changes. So that's been happening a lot. If you're leveraging software, it's going to do that on an automated basis for you on top of track things like ID expirations and whatnot. But anyways, there's ways to automate this and make it not a nightmare for you to do. But the most important thing is just making them aware after you do the initial filing of the updated report requirement. Ideal scenario is do that on a regular basis rather than a kind of a one-time off system that won't be quite as effective. So anyways, it's moving along to this next part here. All right, so we're going to talk a little bit about the willful violation criteria. So there's been a lot of information. I don't want to touch these reports because if we, transpose an address or something like that, it's going to be a $10,000 fine and they're going to grab me and throw me in jail along with the client. FinCEN has made it pretty clear they don't intend to do that. there's going to be a huge bucket of companies that don't file. And also, if you look at the FAQs, anytime they talk about the penalties, they have the word willful in front of it. So we're going to talk a little bit about willful and kind of what that looks like. And their exact language is penalties apply for willfully filing a false or fraudulent beneficial ownership report, or willfully violating the BOI reporting requirements. So what we're looking at here, let's look at a couple of situations. So say a client files a BOI report that includes an address that doesn't match the tax return or makes a typo in an EIN, right? Hard to argue that that's a willful situation. One other note for you all, firms filing this, you don't necessarily have a way to make sure this information is 100% accurate. That's just impossible to do. If a client chooses to omit an owner or, intentionally, disguise something, there's no way to know that. So all engagement letter language you're going to have around this is going to rely on them to sign off, just like it would on a tax return, to sign off on the accuracy of the information so you can then file it on their behalf. But they have to take responsibility for that accuracy. And we do have engagement language and whatnot that can help with this process. If you don't have engagement letters, feel free to reach out to Monica if you'd like a copy of that. We're happy to share that. But anyway, so you definitely want to include in your engagement letter that they take responsibility for the accuracy of the information. But that's going to be a hard one to argue the willful criteria. What happens if that happens? Well, best option, if it's within 30 days, file a corrected report. If it's after 30 days, file an updated report. Do your best to remedy the situation, and likely that's going to be the end of that matter. Another situation. So client intentionally omits a nefarious owner, right? This person was on the North Korean high-level government official, right, on all the politically exposed lists. That's a trickier situation, right? But at the end of the day, as a firm, if you're getting proper sign-off that they have added everybody on that report that you are aware of, and you're simply helping them with the filing process of submitting that, the willful is going to fall back to them, because willfully they are omitting an owner that, to be discovered later around this report. Now, likely, your clients, you have a relationship with your clients. I think it's unlikely that anybody here on this call has a client that, is secretly housing a North Korean government official on their cap table. But anyways, definitely be aware you want that engagement letter in place that makes them take responsibility for the information and makes it very, very clear, that you're going to file the information as they provide it to you. So that's going to be a very, very important criteria. Recommended resolution, drop that client right away. And do what you need to do to take next steps to make sure you don't, help them with any more of these reports. And the last one is client creates a new entity but fails to file within the 90 or 30-day, timeline in 2025 that's upcoming. This is a very common scenario. We get a lot of questions around this. We had an entity, our client formed an entity. They did it in March. It's December. They haven't filed the report. What do we do? File the report. The best option is just file the report, as soon as you're aware of the scenario. There's a lot of people that miss this deadline. In fact, I might even say, just based on looking at this data all of the time, might even say more companies that were formed this year didn't file the initial BOI report than did file the initial BOI report. So this is a huge bucket of noncompliance, definitely something that needs to be addressed with ongoing educational campaigns from FinCEN and frankly, firms like yourself who are very, very helpful in distributing this information to the private sector. So yeah, best option here is file that report, when you're aware of that situation. Likely there's going to be less problem around the willful criteria in the first year of the rollout of this thing, because it's very reasonable people miss this because they weren't aware of it. But if it's 2028, CTA is still in full force, it's going to be harder to argue that missing this was not a willful criteria. So anyways, definitely, if you're in that situation, I would say help that client with that initial filing. And as I said, likely it's not going to be much of an issue. Okay. To touch upon a couple of questions from Terry, I don't see this surviving one way or another. It's hard to predict these things. Absolutely. There's definitely been a lot of friction on its path already. And it's seemed to sort of jump through those hurdles so far, but you never know with these things. You never know. It's definitely a useful tool. And the irony here is we actually require this from overseas governments for access to the SWIFT system. So if you go set up bank accounts overseas, they report back in these details. But the crazy thing is we actually don't, take this information in our own backyard domestically. So anyways, they're trying to plug this hole where, somebody can create an anonymized entity, park a bunch of, money laundering, terrorist financing, drug trafficking, sanctions evasion type assets in it, and it goes completely blind to the US system. So that's kind of what they're trying to plug in. The background of this, the reason they're pushing forward is they're trying to plug a national defense loophole here, but it's been a rocky rollout. That's absolutely true. Patty, a report was filed but missing an owner. I tried to amend a report that was missing an owner, but kept getting a status of rejected, resolved, validation error, and BOI. Our ID says unable to assign. What I would probably say is instead of click corrected report, click updated report, and it'll take it. Yeah, I think because that BOIR ID is actually the first step of validation. And what it's saying is we don't like this filing because it's not adhering to our database logic. So most likely it's because you're trying to do a corrected report after the 30-day mark. So I think that's probably a resolution on that one. Okay, so choosing a path for BOI reporting, right? Firms have different strategies around how they want to address this. 80% of firms, I would say, are interacting with BOI for their clients. What they are doing is they are, they're handling this in-house. Whether they're assigning a staff, go collect this information, get these engagement letters signed, type it into FinCEN, get back the transcript, share it with the client, remind the slower clients, remind those owners that don't finish, send those updated report reminders afterwards, and doing all that process. Or they're just licensing software to automate it all and take about 5 minutes per report. Either way, there's typically some process that you're choosing in-house to adhere to that process for your clients. I'd say 80% of firms interacting with BOI are doing that. Now, I'm going to weigh the two options. There's also a hands-off approach. There's about 20% of firms that prefer to say, we don't want to touch these reports, but we need a place to send our clients that it's not necessarily FinCEN's direct portal, because a lot of them get confused when they get there and they get the reports wrong, and we end up having to deal with it later anyways. So those two pathways to kind of weigh what it looks like. If you're taking the hands-on approach, typically after paying for the cost of operations or software, you're retaining about $300 plus of filing revenue. The market price in these reports is fairly high. We see, depending on your market, anywhere between say 350 to 550, depending on what market you're in and what clients you're serving. So definitely, even after covering cost of software or operations processes, there's a good amount of revenue, remaining there. What it looks like to do that, if you're using kind of a more automated flow, is you're importing your information into likely a portal, if you have software or whatever kind of system you're using, if you're setting it up in-house. You're inviting the client to fill in missing details, and then you're e-filing the reports. So pretty straightforward process to go through on that side. The important liability controls you need to be aware of, though. Clients need to sign off on all the filings. That's key. So if you're using software, it's doing that for you. It's getting that acceptance capture. If you're not, make sure you get the engagement letter signed. Next, let them know about updated reports. That's very important. Let them know within 30 days of a change, they need to let you know to do an update. And then the last one is transcript tracking. Every filing needs to end in a transcript. That's how you know the filing got complete. So you definitely want to make sure that that's in place. Software, once again, does that automatically. If you're not using software, replicate that process. Get a transcript on every file. So on the hands-off approach, typically there's going to be some kind of revenue share component if you opt into those types of programs. Typically, you're going to see somewhere between $70 to $100 of revenue share per filing. Now, the nice thing is this is hands-off. Typically you're going to get a special link. You direct the client to the link. The platform, will handle the rest of it, handle support and whatnot. So that's what that looks like. You're registering a referral link, clients completing it, right? And you're typically getting a CSV or some other kind of report, letting you know which clients have done this. Nice thing about this, no liability controls to implement because you're not doing the filing in-house. You, in this case, referred it away. So anyways, a couple of options there for what that can look like. Now, some details on pricing. This is something that updates fairly frequently, so we like to make sure we're getting new information your way. And yeah, so based on if you've been on the last CPE with us, you kind of probably saw just slightly different numbers, but it hasn't changed too much. I've seen the range maybe widen. So for the initial reports, 300 to 550 is the range that we see a lot. I would say 300 for more Midwest, smaller town, maybe cost sensitive, client groups under firms that, in those areas. As we start to get into like LA, San Francisco markets, New York, the rate, actually New York's kind of New York's strange because things do cost more in New York, but it's also competitive. So it's not necessarily the highest price markets that we see. But anyways, yeah, as you start to get into those areas, you see prices approach, 550. Frankly, I think in LA, most prices are 600, 650 per BOI report per entity. We generally do see firms apply a discount as well if client has many entities they need to do this report for. So if they say, well, I have all these Airbnb LLCs I need to do as well, you're typically going to give them a bundle price or something where, you're steeply discounting reports after the second or something like that. A note on updated reports. So I'll often see pricing between 200 to 350 for the updated reports. And then a lot of firms are actually going towards the lower end of the spectrum if clients are subscribing to this. I'm seeing a lot of this in place because as firms are rolling out BOI, they realize, okay, we need to set up all these processes to do all these filing, these 8 steps of informing them, collecting the information, getting the IDs, getting sign off, filing to FinCEN, getting the transcript, sharing the transcript, doing the reminders, tracking everything. It's a big process. Or software, and then we need to pay for the software. So because there's some underlying infrastructure cost to this, firms are needing to keep that in place because they need to be able to offer the updated reports to the clients. So a lot of them are offering per EIN pricing packages that can vary. I typically see a lot of 100 to 150 annually per EIN. And what that'll typically cover is the cost of, keeping those reminders in place, making those updated reports easy to file. If you have software access to the dashboards, and definitely checking transcripts come tax season against the latest BOI report to make sure that they're not going to trigger a penalty as well by filing mismatching information between the two databases. I don't often see bundled reports in at this price, but sometimes I'll see, 250 per EIN and include an updated report or so. I've seen in the HOA sector, 400 per EIN includes up to 3 updated reports. So you can kind of price this, according to your client groups, but this is something that we're seeing more and more of. So definitely something to be aware of as well around this. All right, pausing for a couple of questions here. Would not firms who already do the tax work have the ownership information to complete on this form? Why would additional data collection be necessary? So one of the reasons is the operations address for these reports. I'll go through a couple of data points around it. So the operations address for reports is not necessarily, say, the PO box that they're used to using or a third-party registered agent address that they're used to using. For the office address, FinCEN wants the specific address where they could go knock on a door and speak to an owner. So a lot of times that's a president's home address or something for a lot of these entities. So that's an important differentiation between the two. A full list of DBAs needs to be on these as well. People with substantial control need to be on these reports. So if you have, say a tax return for a partnership, we'll show everybody who's at 25% or more. That will be clear. But sometimes on the tax return, it's going to be the entities listed at, say, 30%. The way BOI reporting works is it looks through those entities and it wants to know anyone that when you divide out their ownership through the entity meets that 25% threshold. So say an LLC owns 80% of a reporting company and there are 2 people on the LLC. Well, the BOI report will look through the LLC and report both of those people because they have 40% when you include the 2. The other one is substantial control. Your substantial control people are not necessarily on the tax return. You might have that CEO who has 5% of the company, not really signing off any documents because the CFO does that. So, that person might not be on there at all, but they definitely have substantial control. So they need to be on the report. So, and then the other one is company applicants. Anyone who creates a company needs to be on the report. That person might not be in the tax return at all because sometimes it's a third party, like an attorney or somebody like that. So anyways, definitely some differentiation between the two to be aware of once you kind of dive into it a little bit. All right, shifting on. So supporting ongoing compliance, what that looks like. Best situation here, right? You should notify clients of the ongoing report requirements. Ideally, at the very least, you're telling them after doing the initial filing that they need to do updated reports. Better scenario is you have an automated email that's going to regularly go out to those or software to do the same. That's going to keep them aware of when they need to do those updates and make it easy to request those. The next, of course, supporting ongoing compliance, make sure you're checking that come tax time, that latest transcript against a BOI report. Good ideas are to recommend that they do file the updated BOI report prior to filing the tax return. Best is actually checking that for them and, assisting them with the process to make sure they match because you know what you're filing. They should know what you're filing, but, sometimes, of course, they're going to rely on you to get these things done for them. And if you assign extra stuff to them, they may or may not do it. So anyway, something to be aware of as well. And monitoring for the potential updated report triggers. So the best idea is let them know what can trigger those updated reports. Best one, of course, if you have some software or something in place and you can track when those actions happen to make them aware of those updated report requirement triggers being hit when they are hit. And then fixing client reports. This one's an important section because we get a lot of questions. How do I help clients when they get into these funny situations? So one that's common, and we did actually have a question on this already, omitting an owner happens a lot. It happens a lot because the direct, and also if they're direct filing, it happens at an extraordinary rate. Let me just describe the scenario on the BOI page on FinCEN. In fact, I'm going to show you the BOI page on FinCEN. I'm going to show you why this error happens so often and why you're going to encounter it probably a lot once you start getting more involved in the BOI reporting process. So this is their filing interface here. If an owner has, or if a company has one owner, they manage to skate by this one. But if they have more than one owner, they don't. So the filing interface here doesn't explain what's going on. It doesn't explain, what a company applicant is. The expectation is the business owner has already read the 57-page compliance manual in the other part of the website. In reality, they don't do that. They just jump right in here and they start entering some information. So a lot of times they think they're the company applicant because they're doing the FinCEN report. Most of the time, if they're an older company, they can click this button, ignore the scary message, and they know they don't have to do this step. That's rare. So you're going to see a lot of times your owners, even for the new companies, are reporting themselves as company applicants, or even for the older companies, are reporting themselves as company applicants when they only needed to do that if the entity was formed in 2024 or after. But that's not the area you'll see most of the time. The one you'll see a lot is beneficial owner information. Now, if you scan this page, you'll notice nothing talks about substantial control. So you'll see a lot of times they don't put any of the substantial control people in here. And then it says, okay, beneficial owner information. And then they proceed through a confusing form talking about FinCEN IDs and parent of guardians and exempt entities. And then they do some required fields. They drop their ID in here. And then they do what they do on every form in the entire internet. They click next. And they say, great, I'm done. I type in my email and I get back my transcript. Wonderful. What they didn't know to do was on this page here, there was nothing that warned them. Did you get all of your owners? Did you add all the substantial control people? Nothing said that. So they didn't know to scroll back up here, okay, and look for the blue button that'll reveal itself right there. There it is. And they can add more owners on, go into those drop downs to add more owners. They didn't know where that button was. They didn't know to add those people. Nothing told them, nothing warned them. So they moved right by there. So you're going to get a lot of BOI reports in the transcripts that will have a single owner when you know that they're, a 3-person partnership or there's, 3 people on their corporation. Make sure those two match and understand when you get a transcript that has one owner, that's why that happened. It happens a lot. Yeah, so definitely something to be aware of there. One other detail around this as well, when you actually submit this, you have to wait, a little wheel spins, a little bar goes across. Hopefully it actually gets into FinCEN. If it does, it says, congratulations, here's your transcript. 50% of the time, business owners do not download that transcript because they don't know they're looking for it. They don't know they need to do that. They just say, oh, okay, great. And they get little check boxes on the screen. And they think they're done. The problem is that there's no proof now that they've actually done the report. And there's no way to check in this system, type in an EIN, did the company file or not? That doesn't exist as a tool. So, when it comes tax time, you're going to want to make sure that they did the BOI report, but they're not going to be able to prove that to you because they didn't get the transcript. Very frequent problem. So let me shift back to some of those kind of recommended fixes. We'll have a couple of minutes here, so I want to make sure we get to some of these last points here. So yeah, if you see omitted owners, that's why. Recommended fix, file an updated report, including all the owners, because they were not, it wasn't a willful error on their part. They were unaware of it. But you want to make sure that they do get that in because obviously that's going to be a problem when there's an IRS database that says there's 3 owners here at 30% and they file a report with 1 owner. That makes no sense. The next one, no transcripts. This one's a tricky one. What we've seen firms do in this situation a lot is file updated reports with the exact same information over the top of the first. It's fine to do. You can file as many updated reports as you want to do, and it will get a transcript. Then you'll have the transcript. That's wonderful. You have proof. You have a baseline of their BOI compliance now. You know that's done, and the box is checked off. So some firms are saying if you don't have a transcript, I can file the updated report for you, making sure you have the transcript and manage the BOI compliance for you as part of the services that we do here. That's very popular, as an approach to take around this, because obviously clients, are going to want to know this is done and managed, and you have no way to know it's done if they just say that, okay, I think I did this. You don't know. And a lot of times the FinCEN system does error out as well. So they might have got to that last step, had a validation error, put it down and say, I think it's done, because it happened 3 months ago and they kind of, forgot about what happened. Another one is wrong addresses. We see this one, or a company applicant. Best option here, if you're outside of the corrected period of 30 days, update a report, refile right over the top of it. And that's going to be the best approach for you there. So I think that kind of takes us through everything as well for you. One thing I would recommend is definitely keep super close track on the appeal system as well. Actually, Monica, if you want to drop that page in the bottom there, that appeal is going to have a next step on Friday. It's going to make you very much aware of what's going on here in the BOI sphere. So we're going to keep that updated. We'll keep the PACER documents online there. Our counsel that we use is advising, as to good practices to have market, which we're including there as well. But anyways, yeah, as of Friday, we're going to see what happens to BOI report. I'd say that's a very monumental date. I don't see the judge carrying it into next week because obviously it's Christmas week. Judges are people too. They don't want to, sit there, on the bench for Christmas week trying to figure out, some case that fell in their lap in the last, 10 days there. So anyways, keep a good eye on that. And then let me see if we have any other questions. Well, I think here, let me, should I take a minute to answer these last couple of questions? Is that all right?
We could take in about another minute. Yeah, that's fine.
Okay.
Thank you.
All right. Couple quick questions here. Would not firm, okay. What should clients do if not in good standing with the state or as old businesses not officially closed? You'll want to file those reports. The inactive company exemption only applies to companies with no assets formed in 2019 or before. If a corpse charter is forfeited in 2024 by state, is BOI reporting required if filing is reinstated? If the company wasn't fully dissolved in 2023 and it crossed it all into 2024 in a non-dissolved state, you need to file the initial report, no further report after that if it goes on to dissolve. If BOI stays as unconstitutional, do we still need to keep up with changes? Not really, but the government's going to push the appeal forward anyway. So I would just say in that case, if the stay doesn't get granted and the injunction stays in place, you'll want to make sure to watch for the end of that appeal process to see what's going to happen next. Okay, and that takes us through everything. Thank you for joining today. And yeah, Monica's got her email there. If you have any questions, feel free to reach out.
Charles, amazing. You are a wealth of knowledge and we appreciate you being here today. Again, Monica's email is in there and the tracker is in there in the chat as well. I really appreciate you being here today. Thank you so much for the insight. Have a great day.